obligations under jus in bello, specifically occupation law, not to hinder or obstruct humanitarian assistance. 3, Israel's obligation under international human rights law not to hinder or obstruct humanitarian and development assistance and to facilitate early recovery and reconstruction while the Palestinian people remain in their land. And finally, I will conclude with the legal consequences and a summary of Egypt's submissions. Mr. President, Egypt respectfully submits that the obligations of Israel, the occupying power, apply in the entirety of the Palestinian territory occupied in the 5th of June 1967 war, namely the West Bank, including East Jerusalem, and the Gaza Strip, which constitute a single territorial unit. In determining whether a territory remains occupied, this court has observed that the decisive criterion is not whether the occupying power retains physical military presence, but rather whether its authority has been established and can be exercised. Based on this, the court concluded that after its so-called disengagement, Israel remained capable of exercising and continued to exercise certain key elements of authority over Gaza and consequently to have obligations under the law of occupation commensurate with its degree of effective control. It is undeniable that Israel continued to retain control over Gaza, including its airspace, its territorial waters, its civilian infrastructure, and by assuming key governmental functions. Through the Coordinator of Government Activities in the Territories, or COGAT, Israel exercises control over the entry and exit of goods and people into and out of Gaza. Such control has only been further consolidated since Israel's brutal offensive against Gaza, launched on the 7th of October 2023. Mr. President, there is nothing in the jus in bello to preclude the continued application of occupation law while hostilities persist, or where local authorities continue to exercise their functions, contrary to what some states have argued during these proceedings. In fact, many provisions of GC4 presuppose the existence of hostile acts against the occupying power, or expressly require cooperation with local and national authorities, for instance, in the area of healthcare and education. It flows from this that Israel is obliged as an occupying power to comply with the range of obligations embodied in GC4 in the Gaza Strip, as well as the entire OPT, including East Jerusalem. Distinguished members of the court, I now turn to Israel's obligations under jus in bello to ensure and facilitate the unhindered provision of urgently needed supplies and humanitarian assistance. From the beginning of the Gaza crisis, Israel has choked the flow of humanitarian aid, despite numerous Security Council and General Assembly resolutions, as well as orders of this court demanding protection of civilians and the unhindered provision at scale of urgently needed basic services, humanitarian necessities, medical supplies and medical care, including by increasing the capacity and number of crossings. Egypt, for its part, has been steadfast in its commitment to facilitate the entry of aid through its territory. Since the onset of the crisis, Egypt received 903 airlifted consignments and 557 sea shipments of aid. It facilitated the entry of more than 35,000 trucks carrying 534,000 tons of aid. Egypt also facilitated almost 700 fuel trucks, 176 ambulances, and received thousands of wounded Palestinians and their families. The Security Council welcomed Egypt's efforts to facilitate the use by UN humanitarian agencies of the crossing at Rafah, once the lifeline of humanitarian aid into Gaza. Time and again, Egypt's efforts have come up against ongoing Israeli impediments. First, Israel denied humanitarian access altogether by closing all its crossings into Gaza, bombarding the Rafah crossing on the Palestinian side and blocking the flow of aid. After immense efforts from Egypt and the international community, the Rafah crossing was reopened on the Palestinian side on the 21st of October 2023 and the Karma Busailim crossing on the 16th of December. However, Israel continued to impose measures to significantly restrict the flow of goods and aid entering Gaza. Second, Israel's creation of legal, administrative and other hurdles through decreeing that all humanitarian aid trucks passing through Rafah were to be inspected at the Israeli crossing in Nitzana, some 47 kilometers away, severely and purposely delaying and hampering the entry of trucks and blocking life-saving humanitarian items due to multiple rejections. Third, Israel's direct attacks on humanitarian infrastructure, including the crossing itself. On 7th of May last year, Israel launched its military offensive against Rafah, a refuge for 1 million Palestinians and the hub for humanitarian assistance to Gaza, severely impacting humanitarian operations. Israel attacked the Rafah crossing, a decidedly civilian object, rendering it inoperable. Humanitarian agencies were forced to withdraw, all the time while the crossing remained open on the Egyptian side. As the flow of assistance through the Rafah crossing was blocked, Egypt continued to facilitate humanitarian assistance through the Karma Busailim crossing. Fourth, Israel failed to prevent the looting of humanitarian aid consignments and attacks by Israeli settlers. Israel has deliberately targeted aid convoys and aid seekers in mass killings of an unprecedented scale, as well as willfully targeting and destroying Gaza's health infrastructure. In the latest escalation, Israel closed off all crossings into Gaza and resumed active hostilities in breach of the ceasefire brokered by Egypt, Qatar, and the United States. No humanitarian supplies have entered Gaza since the 2nd of March, piling up at crossing points and cutting off more than 2 million civilians from their means of subsistence, effectively killing them slowly. Mr. President, Israel's policy of willfully impeding relief supplies and obstructing the work of humanitarian actors, including UNRWA and other UN agencies, violates a number of international obligations, including the customary international law principle of respecting and protecting humanitarian workers, and the prohibition of attacking, destroying, or rendering useless objects indispensable for the survival of the civilian population. The obligation under Article 55 GC4 to ensure the food and medical supplies of the population if the resources of the occupied territory are inadequate. The obligation to take all measures to ensure public order and safety and maintain the legal order of the occupied territory. The obligation under Article 59 to agree to relief schemes if whole or part of the population is inadequately supplied and to facilitate such schemes by all means at its disposal. The obligation under Article 61 to facilitate the rapid distribution of relief consignments with the cooperation and under the supervision of the protecting power or a delegated neutral party such as the ICRC or other impartial humanitarian organization. And finally, the prohibition of starvation of the civilian population. To justify these egregious violations, Israeli officials have invoked...
Madam, I'm sorry to interrupt you. Could you speak more slowly to facilitate the work of the interpreters? Thank you.
Thank you, Mr. President. To justify these egregious violations, Israeli officials have invoked security concerns and claims of aid diversion while conditioning the flow of aid on the terms of the ceasefire. There can be no possible moral or legal justification for the prolonged siege and starvation of more than 2 million civilians. By its indiscriminate nature, it simply cannot conceivably constitute a legitimate military objective. In addition, the occupier's obligations under Article 55 to ensure and bring in the necessary food and medical supplies is unqualified. The occupier must also agree to and facilitate relief schemes by impartial humanitarian organizations, including ICRC and third states. Distinguished members of the court, what purpose would IHL possibly serve if it can be overridden by the whims of the occupying power? Security and military necessity are already considered in the formulation of the discussed provisions of GC4, which do not envision an exception for military necessity. Israel's denial of humanitarian aid to civilians in need is thus indefensible and clearly indicates an intention to starve the civilian population rather than to achieve any purportedly military objective. Not only has Israel completely defied its obligations under GC4, it has made a mockery of international law by seeking to replace impartial UN and other humanitarian organizations with its own so-called civilian relief mechanisms. This completely defies the purpose of IHL, which seeks to direct relief to the needy population and not the occupying power, and to insulate humanitarian relief from political, military, or other objectives. Replacing international humanitarian actors with an Israeli mechanism cannot but serve to further Israel's agenda to expel the Palestinians from their land and change the demographic composition of the OPT. As already confirmed by this court, any change in the demographic composition of the OPT violates Article 49 of GC4, which prohibits individual or mass forcible transfer. The court has concluded that transfer may be forcible not only when achieved through physical force per se, but when the people concerned, and I quote, have no choice but to leave. Egypt strongly all policies intended to effect the expulsion, displacement, transfer, or deportation of Palestinian civilians, whether inside the OPT or to other countries. Mr. President, I now turn to Israel's obligations under international human rights law, which, as confirmed by this court, is applicable to the OPT. Not only is Israel's deliberate obstruction of humanitarian relief a breach of a slew of fundamental human rights, but its obligations also extend to rebuilding Gaza. Israel has wrought death, destruction, and suffering upon Gaza on a massive scale. The people of Gaza have no homes to return to, no infrastructure, no basic services. An immediate return to the ceasefire is critical if Gaza is to have any hope for recovery. Israel is also bound to facilitate and not impede regional and international reconstruction efforts in Gaza, while the Palestinian people remain in their own territory in accordance with their right to self-determination. Israel must also refrain from obstructing the consolidation of Palestinian state institutions and enable the Palestinian Authority to resume responsibilities in Gaza and consolidate a viable and contiguous Palestinian state on the pre-1967 lines with East Jerusalem as its capital. Mr. President, I will conclude with the legal consequences and a summary of Egypt's submissions. Egypt respectfully submits that the court should advise the General Assembly that, number one, Israel's prolonged occupation remains a continuing violation of international law, and until such time as the occupation ends, Israel is bound to respect its obligations as an occupying power throughout the entire OPT. Two, Israel, as the wrongdoing state, is obliged to make full reparation through restitution, compensation, and satisfaction, either singly or in combination, by ceasing immediately and unconditionally its unlawful conduct, including lifting the siege imposed on civilians in Gaza and ensuring the essential supplies of the civilian population, refraining from indiscriminately targeting civilians, humanitarian, and medical personnel, implementing Security Council Resolution 2735 without delay, and the ceasefire agreements brokered by Egypt, Qatar, and the United States. fully withdrawing from the Gaza Strip and enabling the Palestinian Authority to resume responsibilities in Gaza, including border control. Agreeing on relief schemes on behalf of the Palestinian civilian population and facilitating them by all means at its disposal. Allowing unrestricted, unobstructed and safe humanitarian access at scale and in a timely manner through all entry points. Refraining from any measures and practices to expel, deport, displace or transfer Palestinians from the territory occupied in 1967. Refraining from obstructing the presence and activities of the UN and its agencies, including UNRWA, as well as third states providing humanitarian assistance, and repealing the unlawful laws related to UNRWA, as well as upholding the agency's privileges and immunities. Egypt respectfully calls on the court to declare that the Palestinian people's right to self-determination entails their right to remain on their territory and to pursue their economic, social and cultural development on that territory, the territory occupied unlawfully by Israel in 1967, namely the Gaza Strip and the West Bank, including East Jerusalem. This includes the right to receive development assistance for early recovery and reconstruction without being displaced or expelled from their land. Mr. President, the credibility of international law, indeed the credibility of the international system itself, is at stake. Egypt respectfully requests the court to assert its authority and pronounce itself on the General Assembly's urgent request in the interest of peace and justice for the Palestinian people and the entire Middle East. I hereby conclude Egypt's submission. Thank you.